To my explainer tonight, we've seen quite the role in court. Remember, it's exactly a week since the 5-judge bench ruled regarding the BBI case, and it's most likely headed to the appeals court, and who knows, perhaps the Supreme Court as well. A number of terms have come up that confound just about all of us. So for you to be able to follow that, I've broken down some of the terms that are being used in the courts today. First one, we start with a stay order. Now, a stay order seeks to bar or suspend the enforcement of an order that's been issued by the court. The court would agree with the one applying for the stay order, having found that the reasons are justified. For instance, in the BBI case, the 5-judge bench at the High Court found that the IEBC does not have the right quorum to undertake its business. But this order was suspended to allow the IEBC conduct the 3 by-elections this week, because IEBC applied for a stay of order by the High Court, arguing that its preparations were already in place and that there was not enough time to comply with the orders of the court. Now, a stay order is not indefinite or permanent. It is issued pending the occurrence of something else, like an appeal or compliance with the order that was initially issued. Here now is another term, and that is an injunction. Now, an injunction restrains a party from undertaking certain acts or duties. In legal terms, considered a negative order that's been issued by the court. It prevents a party from doing something that would render the case and its possible outcome irrelevant, or that would mean the court decision would be overtaken by events. Again, in the case of BBI, the court issued an injunction against the IEBC, barring the electoral body from preparing for and conducting a referendum. You'll remember this. An injunction is also known as a conservatory order, so you'll probably see those two terms interchanged. It basically serves to maintain the status quo, meaning keeping things as they are, pending determination of the case by a court of law. Now, at the end of the case, the court may issue a permanent injunction, as it in fact did when the 5 judges issued the permanent injunction restraining IEBC from conducting a referendum until, of course, the IEBC either complies with the orders regarding its constitution or indeed appeals the decision. Now, permanent injunctions are issued at the end of the case when a court is delivering its judgment, which brings me to the next definition. What is a judgment and how is it different from a ruling? Let's begin with a ruling. Now, during the course of the hearing of a case, parties can make certain interim applications or even seek the intervention of the court on issues that are arising from the lawsuit. So directions are given by judges in the course of an ongoing case, and those are the ones that are known as rulings. In respect of the BBI case, remember, 8 petitions had been filed. Now, before all parties could be heard, one of them made an interim application regarding the IEBC and what would happen if they had been allowed to proceed with preparations and conduct the referendum, that it could possibly render the outcome of the case irrelevant. This interim application is what resulted in that temporary injunction that I've already explained. Now, a judgment is the final decision that comes at the very end of the court case. A case is won or lost through a judgment. In the BBI case, the petitioners won and the respondents lost. And now that takes me to the next terms. That is notice of appeal and appeal. Now, granted, even we in the media have gotten this wrong. Now, as we know, right now, either party can appeal a decision that's made by a lower court if they're unhappy. But there are a few steps to this. So first is this one, the notice of appeal. Now, a notice of appeal is just basically an announcement of an intention to appeal. It is not an appeal in itself. Again, referring to the BBI case, there is no appeal yet in this case. The Attorney General has merely indicated to the court that he intends to appeal the judgment. So has the IEBC, by the way. Now, that notice of appeal entails a couple of things. So it entails writing to the registrar of the court that has issued the judgment, in this case, the High Court, and it does not have an effect on the judgment in itself, not yet, right? Because we've said it only seeks to notify the court of their intention to appeal, asking the court to put their records in order for onward transmission to the Court of Appeal. Now, once a notice of appeal is filed, the party or the person who is seeking to appeal then has to begin preparing the appeal itself. So they put together what is is known as a record of appeal. Now, that record contains all the documents that were presented to the court, all the proceedings that were recorded by judges in open court. Basically, everything that transpired during the case is compiled into one document. All of this is then presented to the court together with what is called the Memorandum of Appeal, which now details the grounds on which one is appealing. Now, it is only when this is done and filed at the Court of Appeal with all the relevant documents can we say an appeal has been made. But please note, there is a time cap on this. The person who is seeking to appeal has only 60 days from the notice of appeal to put together all of these documents. Finally, at the Court of Appeal or the Supreme Court, the judges can decide to do this, which is setting aside a judgment or orders that were issued by the lower court. So if the appeal succeeds, the judges can order that the judgment of the lower court be set aside in their entirety. Now, this can also be known as quashing of orders. If this happens, then the ones who won at the High Court would now be deemed to have lost their case at the appeals court. But it's important to remember that they also can go to the Supreme Court if they are displeased. However, the Court of Appeal can also choose to modify or substitute some of the orders that were given by the High Court. So these are essentially the two types of judgments that the Court of Appeal can issue. They can either modify the orders or quash them altogether. I hope that this now gives you some perspective as we continue to discuss these cases, certainly going to the Court of Appeal, perhaps to the Supreme Court at some point in the future. That's my explainer tonight.